Okay. Where's Mr. Jimenez? All right. On this case, have you all done an acknowledgement of discovery?
I believe so.
All right, can I see the file on Joe Anthony Jimenez? Yes.
And Judge, I'm doing the acknowledgement right now.
All right, thank you. All right, so Mr. Jimenez, it's the court's understanding you want a jury trial?
Judge, he just brought him out right now and he asked me to approach the prosecutors and offer the bid.
Okay,
I didn't get a chance to.
all right, go ahead and take care of that then. All right, who's here on Mariano Rendon? All right, Mr. Rendon?
Yes.
My understanding you want a jury trial?
Yes, ma'am.
All right, then we have a jury outside. Have you all already done the acknowledgement of discovery?
We did that last time, Your Honor.
Okay. All right, you're up.
Yes.
State on Mariano Rendon, which case are you all proceeding on? Okay. Yes. And have you done an election?
We're electing the jury judge. I believe we've already filed that, but let me
Okay.
verify that with the court.
All
I think we
right.
did that at the last setting.
Okay.
Just verify that.
And who is the other people who are in the box?
Mariano Freddy and Moreno Vasquez Marco.
What's that?
I'm sorry. Okay.
With,
And then also
Ah, okay.
I
Why is he
don't
here?
know if he's still here.
Yes, why is he here today?
I think he was just scheduled to come in, and I think that's why he's probably here. I don't know.
The docket of last year,
Mhm.
whatever was on the docket, they requested,
Mhm.
and then I gave them a new docket. I told them there was changes, and they did to us yesterday in the afternoon. But weren't able to cancel it, I guess whoever was in the. new
All right.
Okay.
So,
He knows it's been
That's what I said,
reset.
in the
all right,
afternoon.
your case has been reset, okay?
May 15th, right?
Yes.
That's, I believe that's correct, yeah. May 15th.
All right.
We'll be back on that day.
All right, and sir, who are you here for? And And who's your attorney?
Oh, that one,
That's been reset as well. So you're gonna come back on the 15th as well. It's been done at the request of your defense attorneys, okay? All right, thank you. All right, so they can go back.
You want us to keep Jimenez, Joe Jimenez on?
Yes. All right, thank you. And is that going to be for is there an application or no? Okay, all right, thank you. So we're working on a plea paperwork. State on Rendon, you all are not alleging deadly weapon on this, so it's just second degree. All right.
Write the cause number, I've got to write the cause number on it. Okay. Yes. The other one.
Roma, for the other cases, recall them for tomorrow. And we can go ahead and do that.
Mr. Clark? Small Clark?
Yes.
Come up here, sir. Come back tomorrow. Brought it in to you. Anything.
Oh, these
They're flowers. I
They
know,
would-
just wanted to-
Okay.
Right there. So they- they would do it, give you- do that, stick it up. You can see here tomorrow. There you go. Yeah. Cochran? Grab a printer, sign here, you'll be back tomorrow.
Let's see the file on napkin, please.
Please. Go with you tomorrow morning.
Thank you.
Did I see the file on Juan Ramos?
Richard Campos?
All righty. Thank you.
You got people in the.
All right, could I see Anthony Cochran?
dog?
Yeah, they're wrong, but, home search at home. I will- yeah, thank you.
The go ahead and sign here. Your. Usually call for tomorrow, the crowd. Yes, one of those.
Oh.
Just sign there and then you can.
One card,
there you
yes.
go.
Okay. Yeah. Just need the block.
The what?
Oh, yeah,
Yeah,
you
I'm
need
gonna
one of
need
the
copies, yes.
Larry. Blue, I guess, of the
If
last.
you're go, come back tomorrow morning. You're welcome.
IST.
Plug into this phone.
Mansions, if you want him to, they can call for tomorrow as well.
Yes,
Okay, thank you.
you're welcome.
Just wanna make sure.
No problem.
But you know, it's.
Can I see the file on compost?
It does show how. You know.
Just discovery, I think you turn one of the board, but it should be safe for this.
All right, thank you.
Yeah.
Mansion? Have a thing to sign here, come back tomorrow with that. Oh, because we're starting the jury trial right now and someone else.
Oh, okay.
Yes.
Deal.
No, sir, not right now. We're gonna have a panel outside waiting. We need to bring them in. You can speak to the judge tomorrow. Thank you.
For instance,
Where it says defendant? Thank you. You can put the pen back and then I will give you copies. And then we'll see you tomorrow. At 9 a.m. Thank you. Ramos, Juan Ramos, bring it back tomorrow?
Yes.
Okay.
You go.
It's a good man, right? Can I approach on Mr. Ramos?
Yes.
So me and Andrew conferred, I have an offer. I need to go over the videos with my finance still discovery. I'm just asking for a plea deadline date if possible.
All right, where's your client?
Well,
Can I see the file on Ramos? Oh, I think you all have it back. How old are you?
18.
All right, Norma,
Yes, ma'am.
on this case, recall it back that first week in June for a plea deadline date.
I can do June 5th.
All right, June 5th. Once you sign the reset form, you're excused. You're welcome.
Thank you, Judge.
You're welcome.
You have a good day.
You too. Yeah, are y'all ready on his paperwork? All right,
Doing, prepping, paperwork for local stage.
all right, thank you.
Yes, we haven't had it come out yet. Wait, Megan?
Okay, we're on the agenda.
No, a thin one is fine. Oh, thank you.
You're welcome. You want the pen? You want
Yeah.
Yeah, here's the last. Yeah. Oh, this- oh, this- Just a journal.
Oh, no.
You can hear us. You can- you can reach it. I'm sorry. Sorry about that. I got confused. So you can, lot of getting it. Yes. Thank you. It's for Mr. Walker. I think she was an age man. Thank you. No, I know that she took them. He's on the reset. He's gone. He's gone. Oh.
Just.
Yes. Oh, well, she can't sit in the audience. She'd have to be, yeah, she can be on that side. All right, court is calling 2024 CR 008543 State versus Araceli Robles. Can I have parties announced?
Raymond Martinez, Mr. Robles.
And are you Araceli Robles?
Yes.
Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Is there an application?
No, Judge.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, we move to proceed on the lesser included offense of possession of substance one less than 1 gram.
Any objection?
No, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the less included offense of possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense? Ms. Robles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense, possession of a controlled substance, less than 1 gram. They're asking, all right. Oh, just one moment. Did you understand that according to the plea bargain agreement, your punishment is to be assessed at 3 days in the Bexar County Jail under 1244, and there are no applications. Did you understand? Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Judge. Yes.
All right, and they're also taking in consideration 2024 CR 008544. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, of any such motion?
No, Your Honor.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No comment.
State, any evidence to support the plea?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Judge, part of the reason you got entered into this arrangement is that as part of her pretrial and her probation, she's currently on probation in your court.
Mhm.
She went to lifetime recovery, the whole program. She's completed that and has a certificate. And I think we can all assume that she's been testing clean all this time, as we have not had violation reports suggesting otherwise.
Mhm.
So we anticipate, if I can speak for the state, that we're going to jointly ask the court to continue her on probation in addition to the sanction of the conviction.
All right, and I'm assuming you've learned something from this? All right, so here's the thing. I always tell people this all the time, either you want to be clean and sober or you don't. If you don't, then there are only two options, what your future is going to be. Your future is going to be in and out of jail or in and out of somebody's prison, or either somebody's going to end up identifying your body, but it doesn't turn out well. You understand? All right. The court will find you guilty, sentence you to 3 days in the Bexar County Jail under 1244, give you credit for any time served. Taking into consideration 2024 CR 008544, and the court will show that the judgment is satisfied. Is there anything else?
Well, I don't know if you need to deal with the probation case or not.
Are you all withdrawing?
Continue prior to because of her successful participation.
Okay, and I'm hoping the other suspect one that's in this, you're not having contact with them? All right, because they mean you no good, all right? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. Continue, keep up with the good work, okay? All right, you're welcome.
I don't know. If it was on the- I think I got it. Yeah.
Did we retest the?
Sure.
Judge Boyd,
Yes.
I encountered an joiner.
Right.
Went.
Mhm.
Who wanted to stop by. To speak with you about on that.
Yes,
I
that's.
told him
Alright.
that the court was preparing to select the jury.
Mhm.
You may or may not stop by, hoping that the court will come.
All right, thank you. Okay, each side, you'll have 40 minutes. Does anybody want a time warning?
Give you 5 minutes. Go good.
All right, all right,
Just gonna swear in real quick.
okay.
Yeah, I like these mics, they're really. Yeah, these are nice ones, they're like small, they have like a good clips. Like a big wire, and you kind of.
Court is calling 2022 CR 3524 State versus Joe Anthony Jimenez. Mr. Jimenez, if you come down. Can I have parties announced for the record for the state? Defense.
Ruben Flores for Mr. Jimenez.
And are you Joe Jimenez?
Yes,
Counsel, have you received all discovery? Did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? All right. Okay. All right. And there's also an enhancement paragraph. Are you proceeding on the enhancement in each count?
So just regarding count one, regarding count two.
Okay, I understand. All right. All right, Mr. Jimenez, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count one, you're charged with aggravated robbery. If the state is able to prove up the enhancement allegation, your range of punishment is anywhere from 15 years to 99 years or life, and a possible fine up to $10,000. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. All right, just one moment. You're charged with unlawfully carrying a weapon with a felony conviction as a third-degree felony. The range of punishment for that offense is anywhere from 2 to 10 years. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. according to the plea bargain agreement, punishment is to be assessed at 15 years in count one and in count two. They're not, that is, you're right. Okay. So according to the plea bargain agreement, you're to be sentenced to 15 years in count one and count two. You're to be sentenced to 10 years. Counts one and counts two will run concurrently. Is there anything, because I'm trying to do it from memory at my first glance of the paperwork. All right, and there's a $2,000 fine. Did you understand that to be your plea? Defense is at the plea.
It is your.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest? To the enhancement under count one, how do you plead? True or not true? To count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The offer states one attachment.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to a jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1 and counts 2. The court will find you guilty of counts 1 and counts 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you waiving PSI?
Yes, Your Honor.
All right. In count 1, the court will sentence you to 15 years in the prison. Give you credit for any time served. The court will sentence you to 10 years and count 2. Give you credit for any time served. In count 1, there's an affirmative finding of deadly weapon. Counts 1 and counts 2 will run concurrently. There's a $2,000 fine. Is there anything else with regards to sentencing?
Yes, Your Honor. He had a federal case that he got 17 months on. It's then, he entered custody on May 12th, 2022, which is 3 weeks after this case.
Mhm.
And he's been in continuous custody since.
I believe he was released from Karnes County, which is the federal penitentiary,
Mhm.
where they're holding him actually on September 24th, 2024.
Mhm.
But he has been in continuous custody since May 12th, 2022 to present.
Oh, he'll receive credit for that time.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's my question. Why the tears?
I'm citing my library.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, that the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. So what I can tell you is, if you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things. Well, I mean, you had a chance to be in the free world, to be with your children and your wife, but you chose this. So this is where we are. If you would have gone to a jury trial and a jury would have found you guilty, let me just tell you, based on my experience, you know what a jury would have done? They would have looked at your tattoos. They would have known what those tattoos meant, because they would have been told what those tattoos meant during punishment, and they would have gave you life, and they would have went on their way. They would have gave you life on that case. And for the gun case, they would have given you the maximum. So if you don't want to be standing before a judge crying about your wife and children, then stop doing this. All right, good luck to you. Oh, thank you.
Thank you. Very busy.
Oh, thank you. You have a good one.
Did you have a juris? I know.
Okay, just give me one moment.
Yeah, the Odyssey and the internet acting up.
Okay. All right, court is calling 2024 CR 2338B, State versus Mariano Rendon. Could I have parties announced?
Megan Galloway and Jason Gareham for the state.
Very good with the defense.
All right, and are you Mr. Rendon?
Yes.
Defense, have you received all discovery?
Yes, I have.
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Are both parties prepared to proceed with voir dire?
State's ready.
All right, each side will have 40 minutes. Let's bring the jurors in.
All rise for jury.
Oh, just one second. Sorry. All right, now you can bring them in. Oh, I turned off the video. Thanks. Thanks, Roma.
Number one. Gonna be the first row all the way to the left.
Okay.
Two. Follow her.
Thank you.
Number eight now?
Eight.
Okay, it's gonna be the top all the way to the left.
Right.
Number 15. This row. All the way back.
Okay.
We'll figure it out. Oh, yay.
Yes, sir.
All right, everyone, please be seated. All right, everyone, good afternoon. Okay, that is, I gotta make sure you guys are awake. There needs to be a snappy comeback. I know some of us have had big lunches, some of us have had small lunches, and sometimes when you have lunch, you get very sluggish. So, good afternoon, everyone. Oh, that's better. Everybody wants to make sure you guys are awake. I want to let you know that I appreciate you all waiting in the hallway for us. There were other matters other than this case that the court had to take care of, so that's why you were in the hallway. You are in the 187th District Court on the 4th floor, and the judge is myself, Judge Boyd. So, what floor are we on? What's the court number? Who's the judge? Oh, look, somebody's like you. Okay. So I know what you're probably saying. You're like, Judge, we were standing in the hallway, then you gave us a lunch break, and then we were standing in some hallway. Of course, we know where we are, but there's a reason why I ask that. And the reason why is because people who are not normally in this building, sometimes they tend to get lost. And whenever we take a break, you all have to leave the courtroom. And we've had jurors before where we've been waiting for them to come back and we're like, where are they? And then, some I don't have to tell them, hey, we're not doing court on the Riverwalk. Why are you on the Riverwalk? But there have been others, they have been lost and they're gone to a different courtroom. So if you look up and everybody has left you, if you're able to say 187th, because there's only 187th court in all of Texas. You won't find one in any other place in Texas because they do the court in order of when they were created. So this is the 187th District Court that was created in Texas. And in Bexar County, I'm the only Judge Boyd. So if you remember those two names, people will be able to direct you to where you need to go if you get lost. So this case is a criminal case, and it's the state of Texas versus Mariano Rendon. And I'm going to let the state and the defense and Mr. Rendon introduce themselves to you. State.
Good afternoon. My name is Megan Galloway and I represent the state of Texas.
I'm Jason Garahan. I'm also a prosecutor.
My name is Larry Bloomquist. I represent Mariano Rendon.
My name is Mariano Rendon.
All right. And so courtrooms are open to the public. And so in the back, if you could introduce yourself, please. Okay. Thank you. Now, the other people you see in the courtroom, they are staff that are in this courtroom, the people who are here, Ms. Abrams, who's there. So they're unrelated to what's happening in this case. Now, sometimes you're going to see people coming through that door. They're coming through that door because they didn't read the sign outside of it that said, "We're in jury trial. Please do not come through that door." People will come through this door. That's for me to sign paperwork or other things, and it has absolutely nothing to do with this case. So please ignore that. In your possession, you have some important document, and it's very expensive. They're numbers. Whenever you have something that you need to say, just raise that card and wait until someone acknowledges you. Then you can speak. Now, why do I want you to do that? Because I always said if I was in a position to make somebody's job easier, I would do it. To my left is the court reporter. If you can imagine, she has to take down everything that everyone is saying. Everybody speaks at a different pace. Some people whisper. If we all talk at the same time, I've seen her work. She could probably take down 5 people talking at once, right, Cindy? But we're not going to do that to her. So what I need is for everyone to speak one person at a time, even though it gets easy when you start speaking sort of conversationally. Don't do that. Don't anticipate what somebody's question is going to be. And the attorneys are not going to anticipate your answer. They're going to let you finish your answer. So what I'm about to do is a test. And hopefully this will be the jury pool that can follow this instruction. Up until this point, no other jury has been able to follow this instruction, but I'm going to tell you what I've told them. And it's been about maybe 60 or 70 jurors, jury trials at least. Everyone raise your card. All right, we're off to a good start. When I tell you to lower your card, I'll see 6 is getting antsy. When I tell you to lower your card, I want you to lower your card. Jurors 1 through 14, lower your card. Jurors 14 through 21, lower your card. Everyone else, your card should still be up. And if your card is still up, to make Cindy's job easier, if there's something that you need to say, I'm going to ask you to stand if you can stand, because it will make it easier for her to hear. Now, will you all be able to do that?
Yes.
All right. So far, no jury has been able to do that, but I have faith in you. All right. You can lower your cards. All right. So you all have had a chance for the parties to introduce themselves to you. Is there anyone here, and raise your card, is there anyone here who knows any of the parties involved in this case? If you do, please raise your card. All right, I'll take that as a no. So the charges in this case is aggravated assault causing serious bodily injury, and I'll come back and talk to you about that later. Now, neither the state nor the defense attorney can tell you what they think the facts of this case are. The only way you'll hear what they think the facts of this case are is if you are on the jury. Does everyone understand? Yes. So when the state and the defense are speaking to you, they're going to be talking to you in hypotheticals. So don't go in your mind and say, oh, this is about the defendant, because it's not. It is a hypothetical. Don't be Mrs. Kravitz from Bewitched trying to do your own thing. These are all hypotheticals. Does everyone understand?
Yes.
All right. Now, this is a criminal court. It's a felony criminal court. The way people are held over for trial in felony courts is there's an indictment. An indictment is a piece of paper that tells somebody what they're charged with and where they need to appear. That is all it is. It's not evidence of anything. It cannot be taken as evidence of anything. It's just a piece of paper telling you what you're being accused of. Does everyone understand?
Yes.
Because it would be a sad, sad situation if somebody just told you, hey, you'd appear in 187 District Court for trial. You're like, okay, what am I on trial for? Well, we'll let you know when we let you know. How many of you, and I want you to practice raising your cards, how many of you have ever had a traffic ticket? Okay, now this trend continues. There are horrible drivers throughout San Antonio. All right. I've had a traffic ticket before too. And it was when I was 21. So I'm 23, so things are still going on. So anyway, when I received my traffic ticket, that was back in the day where officers had the paper. They would give you a sheet of paper and they had the booklet and they would turn the pages. Now I think they do it electronically or something. So let's say that an officer pulls you over and the officer says you ran a stop sign. You're like, okay. The officer gives you a ticket, and on that ticket, it will tell you, I'm stopping you because I'm saying you ran a stop sign. Well, when you get that ticket, you'll probably end up going to municipal court. It'll probably be on here on Frio or somewhere else. Well, when you go to municipal court, by you're going to municipal court, by you accepting that ticket that that officer is giving you, you're not saying, yeah, it's true, I ran a stop sign. You're just being put on notice. This is what they're saying. So when you go to municipal court, you have a choice. You can go to trial or not go to trial. But they can't say, aha, this person is in a trial over here and they accepted a ticket, so they're guilty. It's just a piece of paper. That's it. You can't use it as evidence of guilt. You can't use it as evidence of anything. And that's the same thing with an indictment. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Rendon because he's here under indictment? Okay. Now, the next thing I want to talk to you is the right to remain silent. I'm sure some of you have seen what, Paper Chase, Mannix, Beretta, The Practice. Where are my Barnaby Jones people? Thank you, sir. All right, so Beretta, everybody understands the right to remain silent, which basically means you don't have to testify if you've been accused of an offense if you don't want to testify. Does everyone understand? I've been a defense attorney, I've been a prosecutor. And I can tell you, as a defense attorney, sometimes, I would advise my client, you shouldn't testify because you're nervous talking to me. You would look very nervous to the jury, and who knows what the jury would think about that? Because sometimes people say, oh, I can tell somebody is being untruthful because they're sweating, or because they won't look me in the eye, or because they're whispering, or because they hold their head down. Sometimes, as a defense attorney, you have a client that's so nervous, you'll tell them, you wouldn't do great. Sometimes people are afraid of speaking in public. Sometimes you have people who have speech impediments. Sometimes, as a defense attorney, I would tell my client, state and prove their case. You don't have to testify. So there are many reasons why a person would choose not to testify. But this is the law. The law is you can't hold it against them for not testifying. You can't even consider it. If you were in a jury room deliberating, you can't even bring up the fact that, a person who's accused of an offense didn't testify. Does everyone understand? Is there anyone here who will hold it against Mr. Rendon if he decides not to testify? The next thing I want to talk to you is presumption of innocence. What does that really mean? It means that everybody is presumed to be innocent of what they're charged of. If it's the running of the stop sign, failure to yield, or in these type of cases, you're presumed to be innocent unless and until the state presents evidence that proves their case beyond a reasonable doubt. Does everyone understand? So knowing that, how much evidence have you heard in this case? And you're not going to hear any evidence in this case during this process because everybody's speaking in hypotheticals. So knowing that you have not received any evidence in this case, based upon the presumption of innocence, if you were to ask to vote right now on whether Mr. Rendon is guilty or not guilty of these charges, what should your answer be? Because you haven't heard any evidence, right? Now, I mentioned to you that the burden of proof the state has is proof beyond a reasonable doubt. When I was in law school, they had the definition. You had to know it backwards and forward. I felt so much pride when I learned it. I had my first jury trial. I paused for dramatic effect. Did you see that pause? I paused in the right place. I put the comma where it should be, the explanation point where it should be. After I completed that jury trial, guess what? There is no longer a definition for proof beyond a reasonable doubt. So the state can't tell you what it is. The defense can't tell you what it is because there's no definition of proof beyond a reasonable doubt. So when I was practicing law, I said, well, I'm going to explain this to the jury because I want them to know this is serious and it's a high burden. So the way I would explain it to them was by telling them what it is not. Next door, you have the historic courthouse with the green rooftop. They try civil cases. They have two types of burdens of proof over there. Their first burden that you probably heard of is preponderance of the evidence. That burden is usually used for traffic accidents, those type of things, or any type of civil thing involving money. Now, what does that mean? More likely than not, if you are ever on a criminal jury trial and you are deliberating on whether someone's guilty or not guilty, and someone says, well, I think this happened more likely than not, you know you are not at the proper burden of proof because that's the burden of proof in civil cases, not in criminal cases. And proof beyond a reasonable doubt is a higher burden than more likely than not. The other burden and the highest burden they have on the civil side next door is what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence that's needed for someone to terminate your parental rights. They're basically saying you're a danger to this child. We can't trust you with this child. And therefore, legally, we will not allow you to be their parents anymore. And we're taking away your right to parent them. That's a very high burden. However, oh, the chairs are squeaking. Is that WD-40 needed? So that burden is very high, but there's a higher burden, and that burden is proof beyond a reasonable doubt. That's the highest burden we have. Does everyone understand? Now, people are going to talk to you about, can you be fair? Are you going to be biased? Let me just tell you what fairness means. And people always give this hypothetical, so I'm going to give this hypothetical to you. Let's say you're excited about jury duty, which I know all of you are, and you get in the mail that you have jury duty. So you're like, oh my gosh, this is great. I'm going to plan my route so I can get there at 8 a.m. And I know they're going to be ready for us to go. They're not going to have us waiting in the hallway. So I'm just going to do great things as a juror. And when you get up, and you get up extra early, you notice your vehicle is on cinder blocks. Somebody has burglarized your vehicles. They've taken the tires off. You're like, man, curses. I can't believe this happened. But you're still excited about jury duty. So you get an Uber, a Lyft, or take the Via, or have your next door neighbor or somebody bring you down. And after you're brought in from waiting in the hallway, you find out that the case that you're going to be sitting on is burglary of a vehicle. Usually people will give you that hypothetical and they're saying, this is not really the case for you, is it? You really can't be fair, can you? So really the correct question is whether or not you will be able to listen to the evidence and make a decision, if you can make a decision on whether somebody's guilty or not guilty. And that would include it in a burglary of a vehicle case if your vehicle had just been burglarized. Or are you going to say to yourself, you know what? I'm not even going to listen to this evidence. This person is charged with burglary of a vehicle and my car was burglarized. Who knows? Maybe it could have been him. I'm just going to find him guilty. Does everyone see what I'm saying? As my grandmother would say, nobody was born yesterday and slept all last night. So everybody has some issues in their life. Everybody may have had some different traumas in your life. So the question about fairness in this case is whether or not, knowing that the charge in this case is aggravated assault causing serious bodily injury, whether or not, if you were selected to be on this jury, would you be able to listen to evidence and make a decision, if you can make a decision, on whether Mr. Rendon is guilty or not guilty? Does everyone understand? Is there anyone here who would not be able to do that? Okay. Now, the next thing I want to talk to you about, there are two phases to every trial, criminal trial. The first phase, people always call it the innocence phase, but that's really not what it is. The first phase is simply, did the state prove their case beyond a reasonable doubt, or did they not prove their case beyond a reasonable doubt? If they didn't prove their case beyond a reasonable doubt, then the person is not guilty. If they prove their case beyond a reasonable doubt, then the person will be found guilty. That's the first phase. So first phase, if you find somebody not guilty, there's not a second phase, because the second phase is what is called the punishment phase. In Texas, the rules are that if you are having a jury trial, that you must make a decision or an election for punishment. So you must say, if I'm found guilty, who do I want to assess punishment in my case? Do I want the court, which would be the judge, or do I want a jury? Does everyone understand? And when a person makes that selection, they're not saying they're guilty. It's just that the law says they have to decide before jury is selected, if they were found guilty, who would be responsible for punishment. In this case, Mr. Rendon has decided if he were found guilty, he would want the jury to assess his punishment. Does everyone understand?
Yes.
Is there anyone here who's going to hold that against him because he said if he were found guilty, he would request that the jury assess punishment? All right, let's talk about punishment. In this case, the range of punishment for this offense is potentially probation or anywhere from 2 to 20 years in prison and up to a $10,000 fine. $10,000 fine, let's start there. Nobody knows where that goes. It just goes somewhere in the world, right? So usually what parties concentrate on is things other than money. So in this type of case, there's a possibility for probation, and also there's a possibility to go to prison anywhere from 2 to 20 years. That's a wide range of punishment, right? Because think about it, it's 2, 3, 4, all the way to 20, or potentially probation. And I'm going to give you some hypotheticals because the next question I'm going to ask you is whether or not you can consider the full range of punishment. Not that you give it because you don't know anything about the case, but that you know that's the range of punishment and you can internalize that. And if you were to find someone guilty, you would be able to take whatever facts are presented to you and try to come out with a range of punishment that you found suitable. So, for example, people always do this hypothetical with a murder case, right? Let's say there's somebody who grows up, the teacher always knew that was going to be a bad child. They kicked the dog, they kicked the cat, they would beat up all the students in class, throw paper on the ground for no reason, rip the heads off of roses, right? And then they grow up, get into fights constantly, at the bar getting into fights, and they end up killing somebody. And now they're charged with murder. That's somebody where maybe somebody can say, oh my gosh, this person deserves a lot of time for this. Now, let's say you have somebody who fell in love with their sweetheart. They knew and their parents knew from the time they met in preschool that they were going to get married. They grow up, they get married, they have children, they have grandchildren. And then they go to the doctor and they find out that one of the persons is very ill, it's terminal, there's nothing that they can do about it. And that person is in extreme pain, and they're going to be in extreme pain, excruciating pain for about 6 months. And that person turns to their spouse and say, hey, can you just help me? Can you, give me all of these pills, or can you inject me with this so I can just, go peacefully? And that person does it. That may be it. That's under Texas law. That's a murder. That may be a case where you say, you know what? That person deserves the minimum. So as you can see, there are different examples where maybe you can see somebody deserves probation. Maybe they deserve 2, maybe they deserve 20. Maybe they deserve the full $10,000 fine. Is there anyone here who cannot consider the full range of punishment in this case? If you cannot, raise your card. All right, is there anyone here for religious reasons are not allowed to sit in judgment? All right. Now, the next thing I want to talk to you is about languages. I love languages. I think they're so beautiful. When I was growing up, I grew up in Louisiana. I already knew where my life was going to be. My friend Tanya said, Stephanie, we should take Spanish. And I told her, no, I'm going to be retired at 21. I'm going to be living in Paris. I'm taking French. I took French, and here I am in San Antonio. And I tell her all the time, I really should have taken that Spanish class, but I ended up here because of school. So when I went to grad school and undergrad, and even in law school at St. Mary's, some of my classmates who are from Middle Eastern countries, the people from the Middle Eastern countries speak no less than 6 languages. I was just like, oh my gosh, this is so great. So I can probably say hurry up in every language because that's what they were able to teach me. I will tell you the hardest language I had to work with was Navajo, but I'm still trying to work on it. So is there anyone here? English is not your first language. If it is not, please raise your card. All right, number 21, 26, and as I call your number, you can lower your card. So 21, 24, 26, 40, 41, 47, and 58. All right, 20, and number 1. All right, number 1, what's your first language? Have you been able to understand everything? Thank you. 21, have you been able to understand everything? All right, I probably shouldn't do this, but I'm just going to remind everybody because I want you all to succeed. Remember about standing when you answer. All right, 24.
Spanish.
Have you been able to understand everything?
Yes, ma'am.
Thank you. Number 26.
Spanish.
Have you been able to understand everything? 40.
Spanish.
Have you been able to understand everything? 41. Have you been able to understand everything? I'm sorry?
I know.
All right. Thank you. Number 47.
Spanish.
Have you been able to understand everything? Thank you. 58.
Spanish.
Have you been able to understand everything? Thank you. All right. I will tell you all, this is the first time we haven't had different languages other than just Spanish. All right. The next thing I want to talk to you about is time constraints, travel arrangements, that's that type of thing, but it can be any type of time constraints you may have. I'm expecting that this trial may potentially be concluded no later than Friday. Is there anyone who has any travel arrangements of time constraints? Raise your card, and once I call out your number, you can lower your card. So I'm going to give you all 2 minutes to do that because once I call your number and pass you, I'm past you. Okay. All right. Number 9, 11, 37, 42, 48, 47, 54, 58, 65, 68, 69, 73, 74, and 75. All right, number 9, what's your time constraint? All right, thank you. Number 11? Okay, thank you. Number 37?
I have no transportation.
All right, thank you. 42.
My grandmother has an appointment in the morning that I have to take her to.
All right, and is it a medical appointment?
Yeah,
What time?
9:30.
All right, thank you. 48. What time? All right, thank you. 47.
For my work.
All right, thank you. 54.
It's work as well.
I'm sorry, what?
Work.
All right, thank you. If you all say that 3 times, that's Rihanna's song. All right. Work, work, work. Number 58.
I have continuing education on Friday.
Oh, I'm sorry, what?
I have continuing education.
Uh,
Already paid the conversion center.
On Friday?
Yeah.
All right, and what is the continuing education for?
TDA.
All right. All right, thank you. 65.
I had tomorrow, I'm attending the concert. It's a non-refundable VIP meet and greet ticket for staying.
For staying? What's their top song? What's their top song?
My favorite one is Home,
I like that too.
and I got the tickets to prove it.
Right. But you're saying these are VIP tickets.
VIP meet and greet, I got them right here. It says.
And what time?
What does that say? VIP.
Yeah.
VIP.
All right, and what time is that?
I have to be there at 3:15 PM tomorrow.
All right, how are they gonna give you VIP tickets, then demand what time you be there?
Because it's a meet and greet, so we gotta meet them before the concert.
Oh, you're gonna get a chance to meet them.
Yeah.
Okay.
VIP.
All right, thank you. Number 68.
Wednesday, my parents are off to Italy for their anniversary. I have to go stay home and watch my siblings. And on Thursday, I have schooling.
All right, thank you. And they're going to Italy on Wednesday?
I think around 4.
Oh.
My dad's gotta keep my mother happy. You know how they are.
I cannot believe he would even say that.
That's true. Got happy wife, happy life.
Okay, are you married?
Oh, but like, I know. I ain't gonna piss off my wife.
Yeah. Yeah. All right, ladies, take note. That's juror number 68. All right, number 69.
Well, my husband works overtime and I have an 8-year-old and a 1-year-old, so it's mostly me taking care of them all week.
I don't know what's happening in Texas where the 8-year-old and 1-year-old are not taking care of themselves and driving. All right, thank you. Number 73.
I have online college schooling and then also a job. I don't get paid if I don't go.
All right, thank you. 74.
I work tomorrow and then I don't have a babysitter for my daughter, like after school care.
And how old is she?
Oh.
And when is pickup and drop off?
She takes the bus home that the school provides transportation for her. So she'll get there about 4:18, 4:20.
All right, thank you. Number 75.
I'm a school bus driver and we only have, it's a small district, so we only have 5 buses and bus drivers. And today I had to make my supervisor jump in and do my route. I have 56 kids.
Okay.
She really didn't want to, but I said, that's your job.
Yeah, so there's no VIP here. Thank you. Now she'll understand how difficult your job is. All right, thank you so much. Did I miss someone over here?
I thought
36?
I had it.
Don't mess up everybody's standing.
Well, I'm a substitute teacher and I just found out I'm pregnant yesterday.
Oh, congratulations. All right. Look, I'm the only one who said congratulations. I guess the rest of them are parents. They already know. All right. Is there anyone else? All right. Yes. What's your number?
49.
Yes.
I take care of my 8-year-old dad, and he has a doctor's appointment on Thursday
Okay. What time?
at 9:30.
All right. Thank you. Oh, see, that's why I said I was going to keep 45.
I'm sorry, I thought the work thing was separate, but just in case it's now, I'm contract, so I don't have any paid days off and I won't get any money if I don't go.
All right. Thank you. All right. Now that you've had a chance to see what number 70?
Oh, for the work thing, I just thought it was for later. Work.
Okay. All right. Thank you. All right. So this is what I can tell everyone. I understand when you say I'm the only person who's working or nobody else can do my job. When people tell me nobody else can do their job, you know what my thought always is? So this is what you're telling me. You're telling me if something were to happen where you retire and say, I'm not doing this anymore, then that job is just, nobody's ever going to be able to do it. It's just going to disappear. So if you're saying you're indispensable for the court, that means if you don't come into work or if you decide you're not going to do that job anymore, that job is just going to disappear from our world because you're the only person in the world who can do it. All right, now that you all have had a chance to see each other, other than standing in line, is there any of you who know each other? If you do, raise your card. Usually we have teachers and students or ex-wife and current wife, but I see that's not the case here. All right, so I'm going to tell you all 2 stories. Both of them are true stories. I always tell jurors that jury duty is an inconvenience. And it's an inconvenience because, one, unless you're down here every single day or often, there are a lot of one-ways. And you try to find where you need to go. There's a lot of construction. And then you see the building. You're like, oh my gosh, I finally found it. It's right there. And then you discover it's a one-way and you can't even turn. And then you start thinking to yourself, there is no traffic. If I just turn, it'll be 2 minutes, I'll be there. And then, of course, you're law-abiding citizens. So you say, no, I'm going to go all the way around and come back. Then I see you all rushing to get to the central jury room. And I tell you all, slow down. They're not starting at 8 a.m. But you all ignore me and you rush. And then it's hurry up and wait. And I say, it's an inconvenience. This is what I call a sacrifice. My family grew up in a small town called Grand Cane, Louisiana. My grandmother, had her children. Her firstborn was a son. Then she had a lot of daughters, then another son. And my uncle was super intelligent. And that was back in the day where all the teachers knew all the students and knew all their families. And when you got one sibling, you know all the other siblings. So my uncle was super intelligent and my uncle kept getting passed from grade to grade because the teacher would tell my grandmother, Miss Lane, we've taught him all we can teach him, and they'd move him to the next grade. Well, when his siblings came up behind him, they didn't appreciate that because the teacher said, we've had your brother. We're going to expect a lot out of you. You better bring the intelligence. So my uncle ends up graduating from high school and he graduates early. When he graduates, a conflict breaks out. You may have heard of it, Vietnam. He goes to my grandmother and he tells her, because of everything that's going on here with civil rights and everything else, I can't prove my lot in life by being around here. So she has to sign up and agree for him to go to Vietnam. And if you can imagine, that's her firstborn son. And I know parents will say, oh, we love all our children the same. there's something about the firstborn because that's your practice child. That's the firstborn. And so she signs up for him to go. And that was back in the time frame. And I know young people don't know what a rotary phone is, but my grandmother did not have a rotary phone. There were no numbers on her phone. You pick it up, the operator answers, and you tell them what you want down. That's why they had the song Concert Guy called Beechwood 45789, because you would pick it up and you would say, I want Beechwood 45789. So they didn't have computers either. They didn't have this 24-hour news cycle. What would end up happening, my grandmother did have a television set. Before that, they just had radio and they would listen to the radio to shows like My Gal Sunday and other soaps on the radio. But when they got a television set, it had 3 stations, ABC, CBS, and NBC. And you really couldn't count on NBC because NBC, the weather had to be perfect. Otherwise, it was not going to show very well. And then at the end of the day, your television set goes off and they play the national anthem and the flag just blows in the wind and you wait to the next day till you get more shows to come on. So she sends my uncle off to Vietnam War. All she has is his number and she's able to write him a letter and you wait for it to come back. My grandmother quickly learned, last thing you want is somebody dressed in military uniforms coming knocking on your door. So I always tell people that's a sacrifice. Memorial Day, Veterans Day, Independence Day, people always want to wave their flags. But then when it comes to your government asking something of you, people are like, I really don't have time. And when you think about it, your government only asks 2 things of you: pay your taxes and serve on a jury. Raise your card if you've actually served on a jury. And when I say serve on a jury, I mean sat, heard testimony, you were a part of a trial. If you look around, that's not even 1/10 of the people in here. So you can lower your card. So your government doesn't even ask you to come up every 3 months or every 6 months to serve on a jury trial. It's once in a blue moon. So that is all your government is asking of you and nothing more. The other story, and people always say, Judge, you have to tell them what happened to your uncle because now people want to know. Well, he did make it back. He's since passed. My grandmother, of course, has since passed, and some of his siblings have since passed. But he made it back. And I still remember when he would come home from the military, I still remember the smell of Old Spice because that's what they would wear, Old Spice. So whenever I smell Old Spice, it takes me back to, the 80s and the 70s. The other story I'm going to tell you is about one of my friends who decided to do civil work instead of criminal law. And she got called up for jury duty. And she said, Stephanie, let's have lunch because I have jury duty. I'm like, this is great. Let's have lunch. So we have lunch. And on the civil side, they're normally not in jury trial as much as on the criminal side. I asked her, how was jury duty going? She said, fantastic. Since I'm a judge, now I'm like, how could it have been fantastic? You were not with Judge Boyd. You were just doing your thing. And she said, I'm not going to be selected. And I said, why are you saying that? And she said, because it's just like in law school. I'm on the back row. I'm keeping my head down. I start laughing. She said, what's so funny? I tell her I'm happy. She says, why are you happy? I said, because we're going to be able to have lunch all week. So other than raising your hand saying, please select me on this jury, the quickest way to be on any jury trial is to be quiet. And I tell you that story because the state and the defense are each going to have 40 minutes to speak to you and get to know about you. That's all the time they have. So please talk to them, speak to them so they can get to know your thoughts and opinions on certain things. Before I turn it over to the state, does anyone need a break? If you do, raise your card. There's no shame in raising the card. All right, then I'm going to turn it over to the state. Yes.
All right, I have a confession to make to you all. I don't know if you recall early this morning when you all were on your way down to the courthouse. But probably around the same time I was making my way down to the courthouse, and because it was drizzling on my way in, it was taking me a little longer than I anticipated to get here to work. And it's no secret that there's a lot of construction going on downtown, and usually I'm a very pleasant driver. And when we come to this merge lane, usually I will let people that are not familiar with downtown merge into my lane. But this morning, I was really in a rush, and so there was a car that was trying to merge, and I'm like, I'm sorry, bud, I can't let you merge into my lanes today. And so I say this to you all to say, if you see me standing here today and you say, hey, that's that jerk that didn't let me merge this morning, speak now or forever hold your peace. So like I said, my name's Megan Galloway and I represent the state of Texas along with Jason Garahan. I know you all probably feel like this, please, please, please don't call on me, but what Judge Boyd did tell you is true. If you don't speak up, you are going to end up. Here you go. I know you all probably feel like this. Please, please, please don't call on me. But if you choose to remain quiet, you're going to end up listening and panel, and you'll see how happy those people look to be sitting in the jury box. Now I want to talk to you about the purpose of jury selection. So what is that? It's like the judge said, we can't talk about the facts of this specific case, but we're going to talk about the law that governs the offense that is charged. And the time that we're going to spend together right now is for us to learn about you and find 12 fair and impartial jurors that are right for this specific case. So who can tell me who this is? Raise your card. You're number 2.
Willie Nelson.
Okay, you're number 3. What does Willie Nelson love? He loves marijuana, right? And this is no secret. He speaks out about it a lot. And so what I want to tell you all right now is I have something called the Willie rule. Okay, and when we're talking about being a fair and impartial juror, it means can you follow the law that the judge gives you and base your opinion based on the evidence and the law. And so when we're talking about Willie Nelson, what kind of case do you think he wouldn't be able to follow the law in? You're number 7. Marijuana. Correct, right? Because he fundamentally disagrees with the law on or marijuana being illegal, right? And that's perfectly fine, but I'm going to be asking you some questions, and if you have some fundamental disagreements with what we're talking about, now is the time to speak up. And so what I call this is the Willie rule. Do you understand the law? Do you disagree with it? And even if you disagree with it, can you put that aside and follow the law that's given to you by the court? Does everyone understand that? Yes. Does anybody have any questions so far? Now, I have a rule in my jury selection, and it's the no waffling rule, because sometimes we get jurors and when I ask them a question, they kind of become the little engine that could, and they're like, I think I can, I think I can. And I'm sorry to inform you, but I think I can is not a good enough answer for me or for the defense. We need definitive yes or no answers. Okay, so keep that in mind when we're asking questions. So it's like the judge said, the burden of proof in a criminal case is beyond a reasonable doubt. And so what does that mean? The judge will let you know there is no legal definition for that. But it's not beyond all doubt. It's not beyond all unreasonable doubt. It's not beyond a shadow of a doubt. And it doesn't mean that you're 100% sure. It goes to the elements of the offense. And so if you were 100% sure about what happened, does anybody know what that would make you in the case? 11. A witness, great job. Okay, and so I have this little demonstrative that I like to put. Can anybody raise your card if you have ever come home to this situation? Okay, juror number 13. Can you tell me, based on what you see on the screen, What do you believe happened?
All that and bad.
Okay, and how are you able to tell that?
That's all the place.
Okay, and so that's what we kind of talk about when we're talking about beyond reasonable doubt, right? It's what does the evidence support? Now, in this scenario, is it possible that somebody decided to break into this home and just knock the trash can over, leave all the trash spread? But there's no signs of forced entry, there's nothing taken from the home, and just the trash was disheveled. Yes, that is possible in some universe, but is that what the evidence points to? No, right, because there's no forced entry, and there's nothing taken from the home. Does that make sense? Okay, does everybody understand the concept of beyond reasonable doubt? Okay. Now, knowing that the standard is beyond a reasonable doubt, is there anyone here who would hold the state to a higher burden and say, you need to prove your case 100%? I'm gonna hold you to a higher burden than beyond a reasonable doubt. Anyone that feels that way? You're smiling. What are you smiling about, 11?
I mean, I would say the same amount. I mean, I'm just the same way that y'all will hold, defendant. Or like making sure that they say the right things or, they plead their case. I feel like the state will have to plead their case as well.
Well, just to be clear, the defendant doesn't have any burden, right? The burden rests solely on the state. The defendant doesn't have to bring any evidence. It's our burden. It's something that we welcome. But what I'm saying is the law says that the burden is beyond a reasonable doubt. And so that's a burden. Are you saying that you're going to require us to prove our case higher than that?
No.
Okay. Does everybody understand that? Okay, and does everybody, they're not going to require the state to prove 100%. Correct. Moving on, I have this question. I want everyone to answer it. I'm gonna ask you to raise your card. And we're gonna go by group. So the question is, what is your opinion of the criminal justice system? You have 4 choices here. The first choice is you believe it's terrible and it takes away our rights. The second choice is you believe that it's concerning because it interferes with our rights. The third choice is you think it's helpful because it looks out for citizens. And the fourth choice is you believe it's beneficial because it protects us from the harmful actions of others. So if you align most with choice number 1, please raise your card up here. 73. All right, if you align most closely with choice number 2, please raise your card. 1, 9, 26, 32, 36, 37, 45, 55, 56, 57, 61, and 66. Okay, and after I call your card, you can put it down. And then
I'm sorry, you have a card back there.
71, go ahead.
Are we supposed to be answering in the theory of what the criminal justice system is supposed to be, or the way we feel it is in actuality?
The way that you feel it is sitting in this courtroom. Okay, so what is your choice?
Probably.
Okay, I'll get to you then. If you align most closely with, you can go, yes, 11 is choice 2. Thank you, and so is 15. All right, if you are most aligned with choice 4, please raise your card. 4. Yeah, I'm skipping 3 and we're going. So 3, 5, 6, 17, 18, 23 through 25, 27 through 29, 30, 31, 33, 38 through 43, 44, 51 through 53, 58, 59, and 68. Okay, so if you didn't raise your card, I'm assuming you're in group 3, is that correct? All right. Now I want to talk to you about the elements of the offense. Today we're here for an aggravated assault case that caused serious bodily injury. The elements that the state would have to prove to you is that on or about the offense date in Bexar County, Texas, the defendant intentionally or knowingly or recklessly caused serious bodily injury to the victim by, and we will allege a manner of means. So that could be anything from striking, kicking, body slamming, anything like that, but we're not going to get into the specifics here and now. Now I want to talk to you about the mental state. Intentionally is legally defined as the conscious, objective, or desire of the defendant. So when I think about that, I think, did this person mean to do what they did? Knowingly is defined as reasonably certain to cause a result. And so when I think about that, I think, did the person know that that result was going to happen when they engaged in their conduct? And recklessly is defined as a defendant consciously disregarding a substantial and unjustifiable risk. So when I think about that one, I think, did this person know that there was a big risk that that result could have happened when they did that, and they did it anyway? Now, regarding the mental state, the law says that you are not required to read minds. You are allowed to infer this from words, actions, and circumstances. So I'm going to display this to you by my favorite movie, The Titanic. And so don't feel left out if you have not seen this movie before. I'm going to tell you all the facts that you need to know for this hypothetical. So there are 3 characters at play here. The first is Cal Hockley, the second is Rose DeWitt Buchater, and the third is Jack Dawson. So let's look at the circumstances to try and determine Cal Hockley's intent. So what are the facts that we know? We're going to pretend that a witness comes up here and testifies to the following facts. 1, they observed Cal grab a firearm from his personal attendant. 2, they observed Cal shooting this firearm at Jack and Rose. There were many other people in the crosshairs, but Cal was observed chasing Jack and Rose and continuing to shoot at them until the magazine ran out of bullets. So who here can tell me what Cal's desire was during the farm? Okay, very good. Who can tell me what Cal was reasonably certain was going to happen? 13.
Or shoot Rosie.
He was gonna hit someone, right? Or cause some type of injury. And what is a substantial and unjustifiable risk that Cal disregarded? Can anyone tell me? Back.
The other people that were there.
Correct, right? So does everybody understand the mental states displayed that way? Does anybody have any questions about that? Now, serious bodily injury is legally defined as either causing a substantial risk of death or serious permanent disfigurement or protracted loss or impairment of the function of any bodily organ. Now, I want to talk to you all about self-defense. This is a possible defense in assault cases. And it's basically well, this person started it or that person hit me first. Okay, and so let's talk about the law that surrounds self-defense. The law regarding self-defense is that a person is justified in using force against another when and to the degree the person reasonably believes the force is immediately necessary to protect himself against the other person's use or attempted use of unlawful force. And a reasonable belief is defined as a belief that would be held by an ordinary and prudent person in the same circumstances. So under the law, you can respond against unlawful force with force. You cannot respond against unlawful force with an unreasonable degree of force. So let's talk about what that, we'll talk about what that looks like in a minute, but regarding self-defense, you cannot act in self-defense because you were solely verbally provoked, you were in a general fear of being physically harmed, you were angry, or you feel like the person had it coming. Your actions have to be reasonable under the circumstances. Does everybody understand that? Okay. Now we're here to talk about the illustration. Okay, this happened a couple of years ago. It was like the slap heard of the world. If you don't know what this is Will Smith slapping Chris Rock. And so, and regarding self-defense, right? And I'll just explain to you all what happened. Chris Rock was hosting an award show and he was making some jokes and probably inappropriate jokes about Will Smith's wife. And it upset Will Smith and he walked up to Chris Rock and said, keep my wife's name out of your mouth, and slapped him. And so you can tell Chris Rock was in pain and look at the face that he's making and he was like wincing at the time. But regarding this, what would have been a reasonable response for Chris Rock? What would that look like? Jury number 11.
Self-defense, strike back.
Okay, strike back. So I'm gonna start here at jury number 1. What do you think a reasonable response would look like? Well, for him, that's slapping back. What about jury number 2? File charges. Okay, jury number 3. Okay, jury number 4. Okay, jury number 5. Flat back. Jury number 6. File charges 7. Okay, jury number 8. 9. Pushing back. Did I get your answer? Okay, go ahead.
Oh, excuse me, just 1 second. So, I'm gonna pause you. The court reporter is having a little bit of hard time listening because I'm able to see her type up what's being said. So if y'all can remember to sort of speak a little bit slower and louder so that the court reporter can hear. All right, you can continue.
Okay, jury number 2, can you go ahead and repeat your answer, please?
The answer was to do whatever it took for him to prevent Will Smith from striking him again.
Okay, all right. Who else feels like juror number 10? That it would be feasible for Chris Rock to do whatever he needed to do in this moment. Okay. 11, 12, 13, 15, 16, 17, 20, 24, 26, 28, 32, 37 through 40, 43, 44, 46 through 49, 54, 55, 56, 57, 59, 61, 63, 64, 65 through 67, 68, can you turn your card around? 68, 69 through 75. Go ahead.
I could not hear you back there, so can you repeat what you said?
Okay, so juror number 10 said that she believes that in this instance, that Chris Rock's response, that she believes a reasonable response would be Chris Rock doing anything that he needed to do to protect himself from being hit again. My question was, who agrees with that? A reasonable response would be that Chris Rock could just do anything that he wanted. 52, 53, 35, 34, 51. Okay. So in this hypothetical, let's say that Will Smith slaps Chris Rock and Chris Rock produces a firearm. Do you all still think that that would be reasonable to respond to a slap in the face with a firearm? No? Okay. Does anybody say, hey, I think, yeah, Chris Rock needed to shoot Will Smith in this instance, that would be justified? No, right? What about causing Chris Rock serious bodily injury, like breaking his arm or something like that? Who believes that would be a reasonable response? Yeah, go ahead.
I mean, if that's the result that he didn't defend himself.
Okay. Juror number 10. So breaking the arm, juror number 10. Who agrees with juror number 10? Repeat. Can you repeat yourself?
If that was the result it took in him defending himself.
She said if that's a result that it took for him to defend himself, she believes that possibly breaking Chris Rock's arm and causing him serious bodily injury could be a reasonable response.
Chris Rock?
What was your question?
I mean, Will Smith, sorry. Okay, juror number 11, 13, 15, 43, 27, 48, 49, 56, 65, 67, 70, 71, and 73. Okay. Now I have this general question. And the question is, it's a statement that you need to read, that I'll read to you. If I don't believe the defendant acted in self-defense, but I believe that the defendant was scared, it would be hard for me to find him guilty. Does anybody agree with that statement? No question. Does anybody agree with that statement? 73. And so how does the state disprove self-defense? Well, this can come in many forms. It could come with witnesses. We're gonna look at the consistency in the statements that were provided, and we look to whether the actions were immediately necessary or reasonable. So that's just kind of going back to the law that was explained to you all. Now, can anybody tell me what type of evidence that you would expect to see in an assault case? I'm gonna pick on 14 that were incurred. Yeah.
I'll be DNA of some sort, like blood maybe, or. Like,
Okay.
I know sometimes people flesh and they leave the DNA.
Okay. What about juror number, well, go ahead, Sean.
The injured report from the hospital.
Okay, like medical record or something? What is your number? 15. 15, you were gonna say the same thing? Okay, what about you, 16?
I was gonna say number.
Okay, 20,
I was gonna say maybe there's pictures.
photographs, that's a good answer.
Evidence of injury.
18, okay, evidence of the injury. So one thing that I didn't hear from you all is testimony, and we kind of talked about that in the Jack and Rose hypothetical. But I want to just implore to you guys that testimony is evidence. So you are going to hear from a number of witnesses, and the people that take that stand and say what they observed, that is considered evidence. And so you could hear from police officers, civilians, you could hear from any witnesses that the defense chooses to call. But as jurors, you are the exclusive judges of the facts that are proven, the credibility of the witnesses, and the weight to be given to the testimony. Okay. Now I have this question, and it says, what does a victim of crime look like in Bexar County, Texas? Does anybody have an answer for that? I'm gonna pick on you. What is your number?
Me?
Yes,
60.
60.
What is a victim? I pay taxes, so I am a victim. Circumstances are gonna be different for each.
Right, and it's kind of a trick question, right? Because it could look like anybody. It could look like anybody. It could look like any one of us in this courtroom. And so sometimes, you know, people expect for our victims to be perfect little nuns, and unfortunately, that's not always the case. And so when we're looking at imperfect victims, right, we're going to look to the consistency of the statements, as I've already stated, but when did they make their statement? Has their story changed at all? Does their story match up with the other evidence that's in the case? And do they have a bias or incentive to testify or lie? Now I have this slide from, does anybody know what movie this is? I'll finally click on you, 73. What is it? Okay, thank you. Move on. And so in the movie, and this part right here, she is singing a song called Reflection. And the reason that I have this slide in my PowerPoint is because if you are selected as a juror, when you are impaneled, you're going to receive the law from the court, and the court is going to instruct you that you cannot let sympathy play into your decision or your deliberations at all. And so is there anybody that says, hey, I would not be able to set aside my sympathy if I felt sorry for the defendant and render a fair and impartial verdict? Is there anybody here that says that they would not be able to set aside their sympathy?
No,
Okay. Okay, go ahead.
I'm just asking, like, well, how would you know somebody is not putting aside their sympathy?
Well,
I mean, some people out there that hide. I was asking.
No, that's why I'm trying to ask now to figure out, there are people that are empaths, right, and if they feel any type of, sympathy for someone, they're gonna say, hey, I can't put that aside, right, and so now is your time to let us know if you feel that way.
I mean, I can lie.
Can, okay, so who here says they cannot put it aside? Raise your card. Okay, 24, 28, 36, 43, 53, 54, 55, 56, 19, 57, 58, 61, 66, 69, 71, 73, and 75. All right, now I have this question about what is your opinion of law enforcement in Bexar County, Texas? You can do an all the way thumbs down at choice number 1. 2 would be kind of halfway. 3 would be a quarter, and then, or 3/4 of the way, and then 4 is all the way thumbs up. Okay. So if you align most with choice number 1, please raise your card. 45, 55, and 73. Okay, choice number 2. 9, 20, 21, 50, 54, 56, 61, 62, 66, and 70. And then choice number 4.
What about three?
I'm doing the same thing again to save time. Okay, I've been this cute, but don't raise your card because I only have 40 minutes. Okay. So choice number 4 is 4, 5, 13, 23, 26, 28, 31 through 33, 47 through 49, and 74 through 75. So as the judge explained to you, there are 2 phases of the trial. The first is referred to as the guilt innocence phase. That is whether or not the defendant committed the acts that are in the indictment. And the second is the punishment phase. And so a lot more evidence can be looked at in the punishment phase. As the judge told you all, the defendant has elected to have the jury assess his punishment. It is a 2nd-degree felony, so the range of punishment is anywhere from probation to 2 to 20 years in prison. And the maximum fine is up to $10,000. So really the judge already went over this, and you all said that you can keep an open mind and consider the maximum and the minimum. So is everybody still in the same place? They can consider the full range of punishment. And so regarding sentencing evidence, I want to know, what do you all think the main purpose of sentencing is? Is it to punish? Do you have a question? Oh, okay, you're, okay.
You were asking.
Oh, sorry.
I'm bad.
45.
When we're answering this, are we answering what it is or what we think it should be?
What you think it should be. Okay, so I'm gonna ask you and then I'll have you raise your cards. Okay. So what do you think the main purpose of sentencing should be to you? Do you think that it should be punishment, that the defendant should be punished for his actions? Or do you think that it should be rehabilitation, that everybody messes up and can change?
Is it binary? Do I have to pick that?
Yeah. No, what are we?
Yeah, I have a very strong opinion, it's not one of those,
Okay,
so.
so go ahead and move on. Okay. What is it?
It's both.
Both.
Yeah, it's option C.
Okay.
I would agree with some sort, but, I mean, and again, it depends on what they've done in the past.
Okay, okay, so we'll kind of get to that in a little bit. But just right now, your preliminary poll, if you are leaning more towards punishment, can you please raise your card? Okay, so that is 3, 5, 6.
Your first time.
Okay, we're gonna get started now. Okay. 8 through 10, 15, 16. Okay, 19, 21, 23, 25 through 28, 31 through 35, 37 through 43, 30, 44, 46, 49, 53, 54, 57 through 60, 61, 62, 64, 65, 67, 68, 69 through 71, and 73. And then who leans more towards rehabilitation? 4, 7, 11 through 14. 17, 18, 20, 22, 29, 41, 45, 47, 48, 50. 51, do you have your card raised? Okay, 51, 52, 55, 56, 59, 63, 66, 72, 74, 75. Now, getting back to this, okay, what would be the most important factor to you when assessing punishment? And you have 4 choices here. The upbringing of the defendant's criminal history, so that would include whether he's done things like this before or after the offense that he's charged with. The seriousness of the facts of the case that we're here for today, or the impact on the victim. Okay, so if you most align with the choice of the defendant's upbringing, please raise your card. Okay, the defendant's criminal history before and after. Okay, so that is 8, 10, 11, 4, 17, 18, 20, 24 through 27, 30 through 32, 34, 35, 40, 42, 43, 47 through 49, 44, 51, 52, 55, 57, 58, 64, 65, 67, 68, 70, 71, and 75. If you align most with the seriousness of the facts of the case that we're here for, please raise your card. You're 1, 2, 3, 6, 9, 12 through 14, 15, 22, 23, 29, 33, 39, 41, 46, 50, 53, 56, 59, 60, 61, 63, 66, 70, 69, 72, and 74. And then, oh, go ahead, sir. Please raise your card, sorry.
Can you select more than one?
So it was the one that you most aligned with, just to save time, okay? Which one did you pick? Or,
I picked number 2, but then I thought I would go along with number 3.
okay, all right, thank you. And if you most align with the impact on the victim in the case that we're here for, please raise your card. That is 5, 7, 16, 19, 21, 28, 36, 37, 38, 42, 54, 62, and 70. Does anybody here have a family member or someone that you know that was close to you that you deeply care about that was convicted of a felony or misdemeanor offense and you feel that that person was treated unfairly by the criminal justice system?
You said misdemeanors were included?
Yeah, so just any criminal offense. Okay. 9, 11, 15, 28, 33, 36, 20, 42, 45, 47, 48, 50, 66, 69, 70, 71, and 73. All right, so if you just raise your card to that question, my question for you all is, we don't have to get into the specific facts of it, but does your experience and feeling that your family member or the person that was close to you was treated unfairly by the criminal justice system, would you be able to set that aside, or would it impact you in this case? So is there anybody here that had their card raised that they say, hey, witnessing this happen to my family member had such a profound impact on me, I would not be able to set it aside and render a fair and impartial verdict. In this case, it would be weighing in the back of my mind the entire time. Please raise your card. 15, 28, 66, 69, and 73. Okay, so if you just raise your card, please keep it up, please. All right. Okay, so 15, you're saying you would not be able to set that aside, correct? Okay, 28, same thing, you could not set it aside, correct? Okay, 66, same thing, you could not set it aside, thank you. 71, same thing, you could not set it aside.
I would be worried I would be a walker.
Okay, so I'm gonna need you to commit right now. If you're waffling.
I would be afraid.
Okay, so you would not be able to set it aside, correct? Okay, 69, same thing, you would not be able to set it aside. And 73, same thing, you could not set it aside.
I'm a walker, but reasonably.
All right, we all need to stand so the court reporter can hear. And I'm sorry, state, you have 3 minutes.
Okay, thank you. You would not be able to set it aside.
Yeah, reasonably, I'm sure that I do well.
And then just one last time, is there anyone here that for any reason, moral, religious, just cannot send judgment of another person? 61 and 69 and 36 and 22. Okay, that's all I have for you. Thank you so much.
All right, does anyone need a break? All right, so I'm gonna give you all a break. Here are the rules. Number 1, you can leave your items in here, but this means that everyone has to leave. And I'm going to have you all standing back in the hallway by 4:05 p.m. You're not allowed to come in the courtroom, but just be standing outside in the appropriate order. Look to your left. Look to your right. You're responsible for that juror being in line. All right, everyone, please rise for the jurors.
Go ahead and leave your numbers on the feet.
Can I vote?
Yeah.
All right, everyone, please be seated. I'm so glad you all made it back. Nobody got lost. All right, just remember, speak one at a time for the court reporter. And anyone who is not in this area on this front row, please remember to stand when speaking. It'll make it easier for the court reporter to hear. And with that being said, I'm going to turn it over to the defense.
Thank you, Your Honor. Counsel. Ladies and gentlemen of the jury, how are you doing this afternoon? My name is Attorney Larry Bloomquist. And first of all, does anybody know who the luckiest person in this courtroom is? Right here, it's this lady right here. She's the absolute luckiest person in this courtroom. These people are all super lucky because they're the most likely to be in the jury. The poor lady is the least likely to be on the jury. I feel so bad. I know you all want to be on the jury because this lady in the back right here. Okay. Now look, I'm going to spend a little bit more time with you folks over here. Okay. It's not that I don't personally love you guys, but they're most likely to be my jury. These guys over here. As we get back now, I'm going to ask some questions to everybody, and I definitely want to get everybody's input because sometimes you may have a question and it may have 5 other people may have that same question. But as far as some personal attention, the closer you are over here, the more close of attention you're going to get from me and over here. Not again, don't love you. I like to start by telling you a little bit about me and who I am. So my name is Larry Bloomquist. I grew up in Wyoming. Just me and a bunch of cows and some ice and snow. Went to law school. Well, I went to the Army first. I was an Army officer for a long time. Spent about 8 years on active duty, 3 years of reserves before that. Then got outside. It would be nice to sleep inside, go to the bathroom inside. So I went to law school, became a lawyer. I've been an attorney here in Texas for 22 years. I was a prosecutor for a really long time, been a defense attorney for a long time. So what our goal is today is to pick a fair and impartial jury. And that's what we're all here for. And one of the things that when we talk about this, we say, what do we want? We want a jury that's fair. We want a jury that's impartial and unbiased. In other words, we want to pick 12 people that can sit down and listen to both sides and listen to what the state has to say to you and consider that. And we want somebody that's going to listen to what the defense has to say to you and really consider that and then come together to make a decision, okay? So we're looking for a fair, impartial, and unbiased jury. Bias is just, doesn't mean if somebody's bad, right? I mean, some people went to Texas and they're big Texas fans. Some other people went to A&M and they're big A&M fans. Doesn't make either one of them right, but they have strong opinions. But if you're a Texas alumni, went to Texas, and you're refereeing the game between them and A&M, you may not be the perfect referee for that. So we talk about it. You have 2 duties, and you guys have all done the first thing, which is really hard, and that's showing up to come and do your jury duty. And the second part of it is if you're fair to be a fair juror, but if there's some reason why you feel like you're not going to be fair and impartial, it's your duty to let us know. Okay, it's your duty to tell us, hey, there's a reason why I don't think I can be a fair and impartial juror. And that's okay. And whenever we talk about doing your duty, it's jury duty. One thing I learned in the Army, whenever they said the word duty, it means it was going to be something that was kind of hard, right? They never said it's your duty to go out and eat steak and have a beer. It was always, it's your duty to stand guard all night in the middle of nowhere. And that's just how it works. The state has the burden to prove the case. We don't ever have to prove anything to you folks. It's the state's burden to prove this case beyond a reasonable doubt. Now, we're obviously going to bring up a lot of questions. We're going to give you a lot of things to consider, but it's their job and it never changes to us. It's never our responsibility to try anything. I'm going to, between the judge and the prosecutor, they did a really good job on a bunch of things. So I'm going to not beat those dead horses because I think they both covered a lot of these things. But what we talk about proof beyond reasonable doubt is the highest standard in the state of Texas. In order to take your child away, it's clear, we talked about, the judge talked about preponderance of the evidence, just like 51% of the evidence, just a little bit more is enough to win, $1 million in a civil trial. Clear and convincing evidence, way up here, maybe 75% is enough to take your child away from you if the state were to try to take your child away from misconduct. And then this is much higher than that. And again, we can't give you a definition because it's somewhat individual, but it's really that moment when you truly believe something, when you truly believe that you're going to take an act that could affect another person's life in the most serious way possible. do innocent people ever get convicted of crimes? Raise your hands if you think that that happens sometimes. Does anybody think that never happens? You know, we all have a responsibility in that, right? We need to have good defense lawyers that are helping to fight for people. We need to have good prosecutors that are helping to sort out those cases. We need to have good judges and good police investigations, right? That can sometimes be a problem. But the other thing we really need is we need jurors to do what we really ask you to do and really decide whether it's proof beyond reasonable doubt. Because sometimes the easier way out is not the right way, right? Doing your duty is hard. It's going to be hard all the time. Look, the defendant he doesn't have to testify. If you choose not to testify, there's all kinds of reasons why people don't testify. You know, have mentally challenged clients that had all kinds of disabilities that maybe wasn't the best thing for them to testify, and you can't use that against my client or any criminal defendant. So if a client doesn't testify, they don't need to. Does anybody say, hey, if I don't hear from this person, that's a deal breaker for me, I can't be fair and impartial? And if you feel that way, it's okay, but is there anybody that feels that way? How many people here own guns? Just out of curiosity. Okay. How many guns do you have? Just one? You're unique. Most gun owners have 5 or 6. How about you, man? 4 guns, right? 5. See, how many Texans own more than 1 gun? Raise your hands. Okay, a lot of people, right? How many people don't own a gun? Is there anybody who doesn't own a gun? Do you have was that like a conscious decision? You're number 7, why you decided not to own a gun?
Because you're more likely to get harmed by one if you have it in your house.
Right. Okay, because guns are dangerous, right? Do you have a problem with other people owning guns?
No, I think everyone should break.
Of my non-gun owners, does anybody have a problem with other people owning guns? No? It's an individual decision you have to make, right? Because it's a
Excuse
tool.
me, counsel, a juror raised their
Oh,
card.
I'm sorry, I didn't see that. Which juror was that?
Oh,
Juror number 36, go ahead.
I don't think everybody has rights. Some people, my friend died because at 18.
Mm-hmm. Yeah,
That's why I don't believe in guns.
okay, that's fine.
I don't believe everyone should own one. And I don't I'm not going against that opinion, but I mean it's like their own opinion, but it's like I don't believe it.
Okay, well, that's fair. And look, it's okay, because look, we have the right to be, be honest. But like in a case like this, I mean, I'm not saying there's a gun even involved in this case, but if there were, do you think that would be difficult for you?
Yes.
Okay, that's fair enough. But how many people, we'll talk a little bit about this. And, again, when they do a good job about certain things, and I agree with everything they say, I'm not going to beat a dead horse. Should a really good job explaining aggravated assault. We talk about, cause of serious bodily injury to the person, and then either use exhibits or cause the serious bodily injury. Serious bodily injury. My classic example of this, I was a prosecutor on a case, and 2 guys were working on a factory, and they were scanning stuff in. And when they were scanning stuff in, the one guy got mad at the other guy and took his scanner gun and he threw it at the other guy and he hit him in the head and his eye popped out. Right? So when we talk about serious bodily injury, it's an injury that does a couple different things. It could be an injury that if you don't receive medical treatment, you could die from that. It could be an injury that impairs a part of your body. And we can all imagine that's going to bleed terrible. If you don't get that treated, you could get infected, could cause all kinds of bad things to happen to you. Impairment, right? So we all agree that we're going to see better with both eyes up here than one hanging down on the ropes down here. So that's impairment of a part of your body to do something, or disfigurement. So if you showed up to your Tinder date and your date's eye popped out, you'd probably be pretty disappointed, right? We talk sometimes about deadly weapons, and deadly weapons is just anything that can and it's been means to use cause death or serious bodily injury. So gun is always a deadly weapon. Kitchen knife, it's not a deadly weapon while I'm using it to cut my meat, but the minute I go like that and threaten you with it, it becomes one because the manner and the means of the use of that. Self-defense. How many people agree that you have a right to defend yourself? Is there anybody that disagrees with that? Is there anybody that says, hey, I don't believe in the right to self-defense? I think that when we were all in the caveman days, one of the first laws was don't kill somebody else, right? That was the law number one. But probably the second thing they said is, but if someone does try to hit you over the head with a club, you don't have to get clubbed. You can hit him with a club, right? It literally probably goes back to that. What we're talking about is a legal justification. So when someone acts in self-defense, something that would ordinarily be a crime, you can be forgiven for doing that because we're acting in self-defense. Juror number 21, what do you think about that?
I'm not good talking on people.
That's all right. You don't have to be great. Just tell us, we're all just regular people here. Just how do you feel about it? You don't know? Okay, well, we'll come back. So what it means is when we're attacked with illegal force, okay, when someone's going to assault us or use illegal force against us, we have the right to stop them from doing that. Okay. And obviously there's some serious reasons why that would be the case. You know, if we don't stop him, we could be seriously injured or killed. You know, if I started attacking him with a knife and he doesn't defend himself, there's a good chance he's gonna die. And that's gonna cause all kinds of bad impacts, not just for him, but all the people that love him, his family and all those other people. So there's a reason we have a will to live, right? A will to fight, to live, to protect ourselves. We talk about when I'm being confronted with force, I can respond with force, right? Now, if he slaps me, I can't drive to his house, burn his house down, shoot his kids and die. That's excessive, right? So it's got to be proportionate to what's going on. So, you know, if someone uses physical force against me, and the physical force is just pushing, shoving, kicking, anything like that, then I have the right to respond with force. Okay, and that could be it could be anything, like, so I could do any of those things back then. If he's gonna punch me, I could punch him. If he's gonna kick me, I could kick him. I could do any of those things. I could even produce a weapon. In this case, let's say I had a gun, I could point the gun at him and say, stop, get back. As long as my intention is to show him I will use deadly force if I have to. Does that make sense to everybody? It's called threats is justifiable force. And what that means is the law just gives us the ability to use that tool if we need to protect ourselves, right? Just giving us another option in defending ourselves. Anybody ever seen somebody get hit one time and end up falling dead? Has anybody heard of that? Okay, you've heard of that? Anybody else heard of that? Yeah. We had a really unfortunate case like that in Comel a couple years ago. A young man was getting bullied by some other kids. He went to fight one of the bullies. The bully fell down, hit his head and died. That was it. One punch. Nothing that we would necessarily expect to happen, but things happen. And so we have this right to defend ourselves. What do you think about that right to defend yourself? Tell me, just give me your opinion, sir, number one.
I believe that it's instinct. Sometimes you react. And sometimes you react and you either put your hands up or you do like the defendant instinct and it's that it's like you're actually step back. Or you push, you push back.
If you think about it, like if we think back, I think that was a really good example with the Chris Rock and Will Smith thing. We know what's happening now, right? Now that it's all happened, we've all seen it, we've all had time to think about it. But at that moment, when Chris Rock is attacked, does he know that he's going to stop and slapping him one time? Does he know that, sir? How come he doesn't know that? Because he's shown he could do it once. He's shown he could do it once. And the fact that he could do that once is an indication he could do it again. And so he doesn't know when that attack is necessarily going to stop. And he has the right to make sure that he is safe and that that other person stops attacking. We talk about using force to the degree. I'm going to read this because I think it's really important. Section 9.31, self-defense. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary. And that's really important. Immediately necessary. It means it's got to happen right now. So like, if let's say you're threatening to beat me up and I go home and I get an axe and I come back. Right? That wasn't immediately necessary, right? Because I had all the time to go over here. So that imminence is important. It has to be something that I have to do right now, defend myself right now. Okay. It's not something that so that imminence is really important. And it has to be reasonably necessary, right? So if he says, if he, let's say he doesn't assault me, let's say he pushes me by accident. It's gotta be reasonable, right? I have to reasonably believe that he's attacking me. Would a reasonable person, we really call it the reasonable person standard, would a reasonable person believe that they needed to act in self-defense? Well, not in that case, right? Because in that case, his conduct is so minor, it's probably unintentional, it's probably not reasonable for me to do that. Another thing we can't do is the self-defender cannot provoke the dispute. In other words, go to the dance, and here's this guy, and he's dancing with my girl, right? So I go up to him, I start mounting up, he stands up, and God darn it, he's a lot bigger and stronger than I thought he was, right? I can't then, when he goes, I've now pushed him, I've created a problem, I can't then act in self-defense immediately because I've started the fight. Does that make sense to you? Now, he stands up, he's a lot bigger and stronger than I thought he was. I go, guess what? Have her, buddy. Go ahead. I can't afford her anyway. Yours, I'm walking out. Now, if I walk out to the parking lot and he attacks me, I've regained my right to self-defense. Does that make sense to everybody? But I've clearly communicated to him in that case, hey, I don't want to have this dispute with you. And so I've broken that chain. But you have to not be provoking the dispute. You can't go up to somebody, slap them, and then when they hit you back, you stab them, right? Because that's not, you're provoking the dispute. You have a right to stand your ground. How many people have heard that? The right to stand your ground. Okay. I'm an old guy, so when I first came in, we were practicing law. We used to have a duty to retreat if you normally could do so, but we've gotten rid of that right. We now have a right, as long as I legally have a right to be here, I have a right to stand here and defend myself. Okay. Why do you think? Does anybody have an idea why that might be? Anybody have an idea? I'm gonna pick on you, juror number. What do you number? Five. What do you think? Why do you think you might have a right to stand your ground itself?
You're there first.
Right. Well, think of it this way. Could I be in danger if I try to? Let's say. Let me do this. So I decide. Now. Can I still retreat if I want to? Sure, I can. But let's say this. He confronts me. I'm on there's a set of stairway behind me. I have to make a choice. I can either turn around. Does that sound like a good idea if he's attacking me? Probably a bad idea. Or I have to try to back up the stairs. I could end up hurting myself or exposing myself to more dangers. Everybody understand that? So we have a right to stand our ground in self-defense if we believe that that's the best thing for us to do. Understand that this is something that happens really fast. Really, really, really fast. So I've been doing this for a long time. Teach self-defense. These things all happen super fast, and you've got to make a decision. And it's always easier. How many people have heard of the expression Monday morning quarterback? How many people have heard of that expression? Juror number 62, what do you think that means?
You're looking back in reflection, have the time to think about it, and be able to make the right decision. But you're in the huddle and making a play in the game that you have a much harder time making the same decision.
Right. You've got seconds to make a decision about what's the right thing to do. And that can be really hard. Everybody agree with that? That can be super hard when we only have a few seconds to make a decision. And especially if that decision could be our life or our death, right? What do you think about that, man? That, it's easier to money morning quarterback something, juror number 6.
Yeah.
Easier to money quarterback something after the effect, right?
And you think about what if or what could I have done?
Yeah, yeah. I'm sure Chris Rock was saying, hey, when he started walking up there, why didn't I raise my hand? Why didn't I do stuff like that, right? But it's easy to do that in retrospect. He had no idea what was about to happen to him. And in that moment, he just was surprised. And that happens. But if you remember, whenever we're dealing with these kind of cases, we have to kind of think about that time issue, is that we're talking about a decision that somebody had just literally seconds to make. Let's talk about like times when you're not allowed to use force, right? So we're number 7, right? What can you guys give me an idea of some ideas when we might not be able to use force? Right. Yeah, and we have 2 different standards. There's 2 kinds of force. Let me break that down for you. There's force which we talked about, punching, kicking, shoving. And then there's deadly force, which is something that could cause somebody either death or serious bodily injury, right? And that could be anything like, say I was on a cliff and I'm getting into a fight with someone and I push them over the cliff. That could cause them death or serious bodily injury. I need to have that deadly force incident. It's a higher standard. It's when I believe that that person is going to cause me death or serious bodily injury. Now I can use deadly force. That makes sense. So there's deadly force is that injury that could cause death or serious bodily injury. So if I were to shoot somebody in self-defense, I would need to be facing somebody that's going to cause something like that. So that makes sense to you. What about if I start calling somebody names? Like say I came up and I just started calling somebody name. You think they should have the right to run me over with their car or shoot me or something like that? No, you can't have just verbal provocation alone. It's got to be something more. It has to be something where you really believe that there is this threat. Where you really, what we're really looking for is when the person did this, were they in fear for themselves or for someone else? And that brings us to another good thing. Do we have the right to defend a third person? Right? Yeah, so let's say that we're walking to the parking lot and it's after court and we get out, it's a little bit late, and I see this lady right there and someone's attacking her. Do I have the right to defend her? Yeah, I have the right. Now, do I have to defend her? No, I could choose not to, which, I think would be sad, but I have the right to say, okay, well, you're on your own. But I have the right to defend her, and the standard is the same. I can use force to stop someone from using illegal force against her. So when I see somebody about to punch her in the face, I can go up and punch that person in the face to stop them from hitting her. Does that make sense to everybody? Also, at that moment, if I believe that they're going to cause her death or serious bodily injury, I have the ability to use deadly force to stop them. Okay, I'll give you a good example. In San Antonio, I do a lot of these self-defense issues. The number one thing I do, and I get called out a lot of times for crime scenes when things happen. We have a lady who was running down the street and the man was trying to run her over with a car. And two citizens got out. They were both licensed to carry handgun holders and they were trying to stop her from being run over. And they shot at the car and they shot at the man driving the car. They were unsuccessful and that man ran that lady over and killed her. Okay. But were they justified in doing that? How many people think they were justified? Okay. Did anybody think they were not justified? Because they were defending that third person. They were concerned for her safety and they tried to save her. They didn't, but they tried to save her. Go ahead. What, describe that for me.
I mean, he was trying to, I understand the deadly force, but there's a way to deter the issue and try to de-escalate rather than try to go so hard.
Yeah, the problem is a lot of times the bullet won't stop a 2,000-pound car. And that's the problem. They did shoot the car. They shot the car a lot. They hit the car a lot. Didn't stop the bullet. So that's a decision that person has to make. But look, as a juror, you have the ability, you're a juror. You are really the decision makers in these cases. And one of the hardest things about being a juror is you have to bring your own mind to it. And you're gonna have disagreements sometimes with other jurors. We'll talk about this. Is there times when you have, a jury has to be unanimous, right? So we have to have 12 people agree on something, or we have to have 12 people disagree on something, or sometimes we have a hung jury where the jury can't decide. We don't like to have that happen, but it sometimes happens. We got 6 people thinks it happened, 6 people didn't think it happened. One of those reasons why we sometimes have people, sometimes it's easier to do the wrong thing than the right thing. How many people think that? Why do you think so, Jared? Number 11? Why do you think sometimes it's easier to do the wrong thing than the right thing?
Wrong thing rather than the right thing. Sometimes I feel like rules were made to be broken. There's a loophole with everything.
Okay.
Everything is not straightforward like it seems to be. There's always, workaround things.
So sometimes as people, right, we get into groups of people, right? I don't care what kind of group of people we have, right? If I was to separate the first 2 rows over here, and I was to put them in a room, and they gotta hang out with each other for like a couple weeks. They would develop their own unique way of dealing with each other that might be different than the rest of you other guys, right? And it's sometimes it's easier to conform, right? So like one of the problems we have sometimes with jurors, I think, is that we're asking you to sit down, part of your job as jurors is to sit down and listen to everybody else. Okay? She may have some great things. Juror number 12 may tell me some things that I didn't think about. Just like, hey, when this guy said this, I felt like that. And maybe that helps change my opinion about it. But the important part is that I have to maintain my own opinion as a juror, right? Every single one of us has to maintain our own opinion. Now look, let's say I have a jury of 12 people, and I'm one of the jurors, and I believe, hey, I'm gonna say that I believe the guy committed the crime. But all the other people in the jury don't believe that. Maybe there's another guy who's with me, we both agree that he did commit the crime, and all the other people are like, no, he's innocent. We try to share our ideas with them, right? Let's say after a while, the other guy changes his mind and says, no, I think he's innocent too. But I'm like, no, I still believe this person is guilty. Or I still believe this person is innocent. Right? The easiest thing for me to do is just say, oh, 11 people think so. Okay, that's fine. 11's enough. I'll just do whatever they say. That's not what you're being asked to do here. You're asked to individually judge this man and judge anybody who's charged with a crime and come to your own unique decision. Now, you're going to share your opinions among other people, and it's good to listen to people and understand, but you've got to make up your own mind. What do you think about that, your number, what your number are you? 13. What do you think about that, your number 13?
I think, yeah, we have to do, we have to share what we believe, what we think, from what we heard from the evidence. So
Sure.
It's our responsibility. For that.
Sure. Last year, I tried a really serious case where a lady died, and it was a very contentious case. And the jury came back guilty. And the next day we showed up in court and this lady was in tears. She said, I didn't believe he was guilty. I just caved in and I just agreed that he did it. And she was in tears and she was crying so much, we had to stop the whole trial because we couldn't continue because she wouldn't do anything. Her belief was that the person was not guilty, but she voted guilty. You see, that created a huge problem because they'd already said that the guy's guilty. He was already found guilty. Now we have to do the whole trial over. The same thing sometimes happens with people that are biased, right? Somebody has, hey, I thought I could be fair. I said I could be fair. And now I'm doing this and I say I can't be fair. We've had that happen too. There's 85 people in this room. Probably this trial, there's probably over 100 people involved in having this trial happen this week. If you have a concern about whether you can be fair, the time to let us know is now, not 3 days into the trial. That makes sense to everybody. What do you think about that, juror? What's your juror number 15? What do you think about that? About a juror using their own mind about to make any decision?
You tell her.
Sure.
They can go or they not change their mind, but some.
Excuse me.
There's another.
Excuse me, if she can speak up.
It's easier to hear.
There's another, like, somebody can be thinking something different, and then somebody else will think, oh, there's something different, new that they can think, and then somebody decided for a guilty or, change it around.
Yeah, and we can change our minds, right? Everybody agree with that? We can change our minds sometimes. We hear something. How many times have you, somebody said something and then you started looking into it and you started reading about it and you started studying and you go, you know what? And that made sense now, but now I've changed my mind. How many people have done that over time? And you just kind of start to change your mind about different things. We talk about. We talk about my question, and I'm going to do this kind of row by row, okay? And what I'm just going to ask you is this: if you truly believe in either side, whether the person is guilty or not guilty, if you're the only person, will you, as it just row, if you answer yes or no, is every one of you willing to commit to standing by that decision? there anybody that can't do that? Like, no, 10 other people say, I'm gonna go for that. What about the second row back there? Does anybody feel like they can't do that? Over here, third row? Fourth row? Anybody on this side? Say, hey, you know, if even if everybody else says something else, if my opinion is this, I'm gonna change my mind just because it's easier. Can everybody commit to me that they won't do that? Because it's important. These are people's lives at stake. After we establish what's gonna happen, in the event that somebody's found guilty, we go to the punishment phase. One of the unique things about Texas in the punishment phase is we have this huge range. We usually have these huge ranges, right? So in this case, it's 2 years to 20 years in prison. So I'm gonna give you an example of somebody. I'm gonna give you an example of two different people, okay? I'm gonna pick on you, juror number 6. These two different people. So we have a 17-year-old boy who is just an adult in the criminal system in Texas. He gets into an argument with another young man. During that argument, pushes him. The other young man is near a flight of stairs and he stumbles back a few steps, then hits the stairs and falls down and hurts himself. Okay. That's case number 1. Case number 2, we have a guy who's been to prison 4 times. He's 3 of those cases are violent felonies, 1 is a theft. And he grabs a lady against her will, takes a knife, and stabs her 17 times. She lives, okay? She's in the hospital, she's spending time in the hospital, and she eventually survives. Okay. How many people, those people should be treated differently by the system? How many people think that? Does anybody disagree that those people should be treated differently? I mean, technically they committed the same crime, but there's a lot of different aspects of it. One is the seriousness of the offense, right? I mean, the lady who was stabbed 17 times, that's, you'd agree with me, man, juror number 16, that's a lot more serious than the boy who fell down the stairs.
Yes.
And what else is important to you about those 2 different scenarios that make them different?
There seems to be a lot more intent in the second one to cause harm
Mhm.
than in the first piece.
Right. An intent to cause harm, because remember, when we talk about aggravated assault, it can be done intentionally or recklessly, right? Intentionally, knowingly, or recklessly are the 3 different mental states. So in the one case, we think the guy's reckless in pushing the other guy down the stairs. In the other one, we believe, you don't accidentally, recklessly stab someone 17 times. What about you, man? What do you think about that? The intention behind it is important to you. Okay.
Excuse me.
And juror number 17.
If you can,
Oh, sorry.
you can, yes.
The problem is my big old body, all those tacos I've been eating over the years was blocking the sound. So can you say that again, ma'am? You talked about the intention behind it. Is that correct?
Correct.
Okay. What do you think about that juror number? Is it 18, sir?
18, yeah, I mean, I agree.
Okay. Now we're
Ask a question.
Yes, go ahead.
You were saying that if one of the persons was in prison and then committed crime before, the thing allowed to do that.
On punishment, yes.
Oh, on punishment.
So on punishment,
Not during the trial.
there's certain things during guilt and innocence. There's all kinds of rules that we all have to follow. So there's certain things you may or may not hear during the guilt and innocence phase of trial. But there's, like during punishment, that would obviously be something that if someone had committed crimes, the state could bring that up. They could say, hey, look, they've done this, because that is an important factor, right? Does everybody agree with that? Would that be an important factor, whether somebody had committed crimes in the past? Because, it's like, kind of like, go ahead.
That's only during the punishment. You can't hear that during the trial.
There are certain ways that it could happen during the trial, but usually that's reserved for punishment, is what I would tell you. There are certain exceptions to that. Someone says, I've never committed a crime, and they've committed 15 crimes, well, then that's admissible, right? That would be sometimes where it would be admissible, but generally where that stuff comes up is during the punishment. And so we talk about this. This is Benjamin Franklin. Everybody knows this guy, right? He said it's better that 100 guilty persons should escape than 1 innocent person should suffer. It's a maxim that has long and generally been approved. That's kind of a controversial statement. How many people, does anybody agree with that? Does everybody agree with that? Go ahead. Why do you agree with that, juror number 56?
I feel like once you kind of cross that boundary.
Excuse me, if you could stand.
Stand up, please.
You cross that boundary and it's no longer important to ensure that innocent people aren't being punished for crimes they did. It kind of ruins justice. It starts to create a lot of trust in the system.
Yeah, I think that was a really good answer. I think I like that part where we said it degrades our trust in the system, because when we see innocent people that get punished, that's when we start to feel that the system isn't working for us, right?
5 minutes.
When that kind of stuff's happened, that's when we feel like this system is not working for us. Who disagrees with this statement? Go ahead. Why do you disagree?
The counterpoint of what you just said, I think we start losing our trust in the system if 100 guilty people get away with it.
Okay. Well, if you had to err between those two, like if you had to err, so let me advance to this. I'm gonna show you 2 photos. I'm gonna go juror by juror. Which one bothers you more? The first photo is an innocent man spending 30 years in prison. The second photo is a guilty man walking out of the courthouse, triumphant that he just got out of the seat. Which of these 2 photos bother you more? Let's start with juror number 1. Just tell me, if you're innocent, which bothers you more? Sure. Yes. Yes.
Innocent.
Well, they're both bothering, but it's.
You can't go both. I'm asking for your opinion. One of those bothers you a little bit more than the other. No waffling. You got to give us your opinion. You're number 17, I think. No, am I right? 17. I'll give you a second. You're number 18, but I'm coming back to you. No getting out of it.
Innocent.
Is that the guilty one getting?
The guiltiest guy celebrating. He's celebrating that he was found not guilty, even though he was guilty. And the other guy, okay, that bothers you more?
Yes.
Innocent.
All right, so here's the thing. I'm gonna pause. If you are not in these roles, you all need to stand because the court reporter can't hear.
Just stand and give me your juror number, starting with you, sir. Innocent.
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 Guilty. Ma'am,
Innocent.
sir.
Innocent.
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 Innocent. Innocent.
Innocent.
Innocent.
Third.
Innocent.
Innocent. Guilty. Guilty. Innocent.
Innocent.
Guilty. Guilty.
Innocent.
Innocent. Innocent.
Innocent.
Innocent.
Guilty.
Innocent. Innocent.
Innocent.
Guilty.
Innocent.
Innocent.
Innocent. Innocent. Guilty.
Guilty.
And there's no right or wrong answers. What I will tell you is a couple things. I've been using that slide with Ben Franklin for a long time. And what I would tell you is that, I saw somebody discussing this the other day and they did a really good job. One of the other quotes they brought up was a quote by Friedrich Nietzsche, and that says, when you're hunting monsters, it's important not to become a monster yourself. And if you think about it, what he's saying is, like, look, part of our job is we all want to save the community. We all want to save the community. We want to live in a place where we are as safe as possible. And sometimes it doesn't feel like that. Everybody agree with that? Sometimes we're scared because things are kind of rough and everything. But what we can't do is we can't lose our humanity. We can't forget that the people that are sitting at this table, whether it's my client or another person or you or somebody that you loved, gets all the attention that the criminal justice system deserves and gets that benefit because they're presumed to be innocent because they sit here. It's the state's job to prove it. And it's your job as jurors. It really is your job as jurors to listen to the evidence, to consider it, and to truly believe. If you're gonna find somebody guilty, you have to truly know that that person is guilty. And if you fail to do that, then you become the monster that's perpetrating the bad things in the machine. Because we have, although we want to have a safe society, we need to make sure that we're making the right decisions, the right choices.
Counsel, that's your
yes.
time.
I appreciate your time and attention. I look forward to working with the people that are selected, the people that aren't. Hopefully this was a great experience for you as well. Have a good day.
All right, ladies and gentlemen, I'm going to ask you to take your items with you. Wait outside in the hallway, leave your numbers behind. You're not excused yet. Just wait in the hallway for us. Everyone, please rise for the jurors.
Oh, sorry.